But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false. And
does that even matter?
Like half this stuff, I don't know if it's a dream or if it's real.
There is no case law anywhere that the state could find, and the defense has not cited any to suggest there is a reasonable expectation of privacy in DNA found at a crime scene.
How are you feeling?
In the Bryan Kohberger Idaho 4 case, was one of the key witnesses supporting the probable cause affidavit actually dreaming?
In the Idaho 4 case, we have dreaming witnesses and a request to suppress the DNA. I'm Lainey Law.
And I'm attorney Andrew Myers.
And it sounds like we have a lot going into one hearing and even more beyond that.
Yeah, there was a whole day of hearings, 2 days actually. And the first day, we spent most of our time looking at a screen that said the court is closed. The court is closed. Then it said we're going to lunch. Then it said we'll be right here shortly. Then it's still, so it was a long day in the Ada County court in Boise, Idaho, while the parties argued. And then finally, they did come out and hold a public hearing, and they kind of mismatched all of those motions to suppress with a motion whether or not they should have a Franks hearing. So one of the key problems in the case is the defense has challenged whether or not the investigative genetic genealogy process violated Bryan Kohberger's Fourth Amendment rights. And she argued that the whole IGG process and the result involved 3 specific steps, and law enforcement did not have valid warrants for those individual steps. So the whole IGG process should be tossed out, she said.
Our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given, and so this must be suppressed.
So, all right, I don't feel so bad when I rustle my papers in these episodes, because did you hear Judge Hippler rustling his papers? And I think he was doing that because he was getting ready to tangle with Ann Taylor, questioning whether using 4 DNA databases violated Mr. Kohberger's rights by searching those databases. And he really seemed to stump her. Watch this.
I think you have a privacy interest in your own DNA.
Not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
She has no answer.
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree that part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant.
Yeah, and so she does quite well when she's, just arguing, but he had some good questions. He had some good questions for the state, too, and we're going to get to those. But before we do, Ann Taylor also attacked the credibility of the probable cause affidavit itself, pointing without using her name pursuant to the court instructions, but saying, as we could all tell from the context, that Dylan Morton's statements that were just paraphrased in the probable cause affidavit didn't match what she had said during interviews the day of the crime, November 13th, 2022.
An interview they had where The person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is,
That's
I
not
think
me
you have a
ruffling my notes.
privacy interest.
Yeah.
That's not me ruffling my notes. That's her.
It is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page
The judge looks
281.
annoyed.
lines 4 through
He
10.
keeps going.
When this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all.
And so she went into a lot of detail. Apparently, Dylan Mortensen, who she wasn't allowed to mention by name during the hearing, had done an interview, right away that day. And Ann Taylor meticulously went through things that she said. And then, the obvious paraphrases that were in the probable cause affidavit. And if you don't remember, she was the one that, estimated his height and said he had bushy eyebrows and all the rest. And, Prosecutor Ashley Jennings argued, though, now we're switching gears to the Franks hearing, that just mere inconsistencies are not enough to actually have a Franks hearing.
First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing.
So Ashley Jennings is saying, it's all right if there's inconsistencies. It's all right if the things aren't quite right in the affidavit. It has to rise to the level of, willing, wanton, knowing misstatements. But Ann Taylor was unfazed, and she pressed on, saying that the PCA was misleading and included misstatements and failed to address the admitted memory problems of Dylan Mortensen.
The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint, and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor, what they were. And I counted up, and at the very first
He's doing it
interview,
again. He's going.
remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation.
Isn't it important that the witness, as they referred to her, doesn't even know if she was dreaming or if it really happened and she had a bad memory? And all of this information was put in the affidavit of probable cause as though it was a fact. It's remarkable. I'll say it's remarkable. It's beyond belief that they would just write a probable cause affidavit, which is supposed to be a recitation of facts. I was told in law school, when you write an affidavit, it's a recitation of facts, not saying that it's like, oh, somebody that like might have had a few, somebody that has a bad memory and admits that she has a bad memory and also that she might have been dreaming. Is that crazy?
Well, I was going to ask, is this the first time we hear about this whole might have been dreaming? Because I feel like that changes things a lot with this. I mean, how are you going to go by somebody who's not even, I mean, I know what it's like, especially, well, I can't imagine what it's like for her in such a traumatic moment, but a lot of the times when you're going through stress, you start to question yourself. But it could have been a dream sounds a little, yeah.
It's over the edge. It's over the edge. And that's Ann Taylor's point, that, you know what? An affidavit that is used to allow a judge and a magistrate to allow you to go into his family's home in Pennsylvania and blast out the doors and windows, you know, it's unseemly, I'll say. And also that affidavit, and people went into this in extreme detail during this hearing, and we're going to spare our viewers of it. It was also used to get warrants against AT&T and Google and Amazon and all the rest. And we still don't have all the returns from them all. But is this the first time we've heard it? Yeah, kind of factually it is. But I mean, these stories have been out there. And so I shook my head when I heard this. And as neutral as I've tried to stay in this case, the probable cause affidavit recited the testimony of this witness as though it was fact. And I don't know if I told you, you know what I did last night? I did this and I did that. And I tried a case and won $1 million. And oh, by the way, I have a bad memory and I don't know if I was dreaming. Would you believe a word of it?
The whole I have a bad memory and I don't know if I was dreaming it is kind of insane to me, because I am someone, I don't know, I wake up a lot at night. Obviously, I'm not really drinking and out partying, so I don't know how alcohol mixes with that. But I remember when I'm up and walking around, to say like I might have been dreaming. I feel like if you're saying I might have been dreaming, that's admission that you're not sure on it. I feel like it's a totally different thing to say, oh, I was like, I had been drinking, but I got up to use the bathroom, so and da 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 da. I feel like that's completely different than, oh, I might have been dreaming, but I thought I remembered this, and also I was drinking, and also I can't remember things.
Yeah. So before we get on to the next point, I just want to close this point out by saying, you know what, this kind of sort of maybe answers the whole question about why did it take him 8 hours to call 911? All right. Getting back to the issue of suppressing the IGG, the judge confronted Deputy Attorney General Jeffrey Nye about Ann Taylor's contention that the FBI should not have invaded into DNA pools of those various genealogy services.
Databases that by its own policies, law enforcement said they wouldn't search.
So a couple of points on that. First, even assuming that that's all correct and that they violated the terms
Seems to be the evidence.
Oh, the judge didn't like that at all. Don't tell a judge that you assume what he just said to be true. That's a bad move in court.
service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this.
Okay. All right. So one thing to notice here is that we heard from Ashley Jennings, that's for sure. And the gentleman who's speaking right here in the sound clip is Jeffrey Nye. He's one of the deputy attorney generals in the state of Idaho. And I think this kind of, but not 100% proves my point that when the court moved down to Ada County and the city of Boise, that Mr. Thompson would be taking more of a back seat. And look, he is taking more of a back seat, literally here. He's not speaking. He's there. He's the supervisor. And Ashley Jennings, who is his #1 chief top deputy, is speaking. But Mr. Nye, who's been in the case all along, he seems to be taking more of a lead role from watching what was available in the hearings. So I don't know what to make it of all. Do you remember when there were like a dozen motions to suppress or to get rid of the death penalty? Remember that?
Mm-hmm.
And then there were all those motions. Then the judge dispensed of them all with one denial. It was 55 pages because he actually, grounded it with a lot of research in a lot of cases. But he only took one order, kaboom. That's my prediction. My crystal ball is back from the factory. And my prediction is that all of these motions to suppress are going to be denied in one fell swoop. That's my prediction. What do I know?
I mean, what do you know? Even though your crystal ball is broken, you have a pretty good insight. I feel like you generally tend to be right with a lot of these things. It's interesting hearing the arguments go back and forth. As far as with the DNA thing, they do put up an interesting point, and I don't really know how it would be presented if he was denying to have submitted his DNA, or if they connected the DNA through someone else. This whole privacy conversation is really interesting to me, because you hear so many people, they go and get their ancestry tested. I can't speak today, sorry. But they get their ancestry tested, and you're not thinking about how it's going to theoretically implicate you or other people. So I think just the whole discussion on privacy and what kind of privacy are you afforded by submitting your information to this private company, I think this is an important thing to point out, that could theoretically impact a lot of other people, whether you know it or aware of it or not, even if you just have a sibling or some other relative that has submitted their DNA.
You know what? This isn't a legal argument. The legal argument is whether the FBI, by violating the terms of service and going into the gene pools of these 4 different genealogy services, whether by doing that, you can backpedal it and say that was a violation that can be attached to Bryan Kohberger. So putting the legal arguments aside, does anyone really think seriously for half a second that stuff that they put out there is confidential? Come on now, 3 times in my life, and I'm not that old. I'm old, but I'm not that old. 3 times in my life, I've gotten these notices from health insurance companies that my dad has been compromised. You know how you go to the doctor's office and you give them all the information? If you think that's private, you have another thing coming. Also, my bank account was hacked recently. So anybody that gives out information that thinks it's private, you have another thing coming. Again, that's not a legal argument, but I think it's reality in 2024. I'm sorry. So,
Yeah. My thought is even with these terms of services, I imagine that a lot of these companies in their terms of services have it saying that they could freely sell your information to whoever they want.
It's all in the fine print that nobody reads. Nobody reads that stuff. I'm at the doctor's office and they put the little thing in front of me here, sign this. And I said, what am I signing? Oh, well, that's just, consent to treatment. Can I see it? Oh, sure, you have a right. And she goes through all the drawers. She can't find it. They go out of the reception area. They go in the back room. They're probably cussing me out. There's a lawyer up front. But how many times do we sign things and don't even read them? So if you think that you give your genetic information to somebody and it's not going to get around, I've got another thought for you. So, but the issue, to get back to a somewhat legal argument, the real issue is whether the FBI, in going into those services, whether that violates Mr. Kohberger's rights. And the judge was, even though he gave Deputy Attorney General Jeffrey Nye a little bit of pushback on that, look at the judge's posture there. He's just kind of looking at it like, yeah.
This whole time with both of them, I feel like it's all like,
it's like, sure.
He knows he's on camera.
Let's see, what am I going to have for dinner tonight? Let's see, I got to go to the grocery store. I need dog food. I'm out of dogs. I mean, come on. Anyhow, so, the other little tidbit was that we had one of our fine commenters in our comment section who was actually going to drive to this hearing and give us a little report today. We were going to have a little report today from somebody that was in the courtroom, because she's been to some of the other cases and to some of the other hearings in this case. And, through the comment section, we kind of got to know each other, and she was actually going to go and report. Well, at the last minute, the day before the hearing, the judge said, most of this is going to be closed, but then some of it's going to be open. But we're going to stream it, but we're not going to let anybody in the courtroom. So the people that you see in that courtroom, on the right-hand people, right in the middle of your screen is Brett Payne was there. And then in front of Brett Payne was Lawrence Mallory from the Moscow Police Department. And the other people are all associated with the law enforcement. On the left-hand side and all the way on the left, you see the deputy who's got his eye on Bryan Kohberger. And then the woman all the way up front, I recognize the face. I can't place it. But so only people that had a close association with law enforcement were allowed in there. And our commenter, who was going to go and sit in that courtroom and give us just her feeling. We can watch it, but you don't get the feeling of it. She couldn't go. And you know who else was not allowed in? Was our friend Steve Gonzalez. And he was on Fox and Friends this morning. I don't care how you feel about Fox, but he was on TV on the morning that we're doing this, complaining that they wouldn't let us in. And we darn well better be allowed in the trial because we are the living victims. Yeah, the four are victims. And we have to remember that in every episode that this case is about Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Xana Kernodle. But Kaylee's father, Steve Gonsalves, was on national TV the morning we're doing this saying, come on, we don't have a right to be in that courtroom. I mean, I don't care. I can be here. I'm here on the East Coast. That's way out there in Boise, Idaho. But I don't know. I'm not complaining that our person couldn't get in. It would have been nice. It would have been nice. We would have had that little report. But I mean, come on. I think that was the secrecy in this case has gone too far. We had to sit there and wait half of the day while they talked about God knows what, ordering lattes, or, we don't want anybody to know. It was certain that they were talking about Dylan Morton. Even somebody who read one newspaper article would know. But no, you can't. You are not allowed to use her name. Well, everybody knows. So the secrecy in this case has gone beyond anything I've ever seen, and I've been following stuff longer than I want to admit.
Yeah, and you make a really good point as to the victims' families not being allowed in, because I guess I need to ask you, in a court case, are the victims, if they're not necessarily on trial, would they be allowed in to watch?
Well, always. I mean, look at the Karen Reed case. The Karen Reed trial was held in a teeny tiny courtroom. I know because I've been in that courtroom. I tried a case in that courtroom one time. And the faces that we always see are John O'Keefe's brother, John O'Keefe's mother, and other members of the family. And then on the other side of the courtroom, we see William and Janet Reed and Nathan Reed and the others. So yes, the victims are always allowed in.
That's what I was going to say, because the parents are next of kin, so you would think that they would have some right to be in there.
Yeah, I remember when I was a reporter, I would always get mad because, if there weren't enough seats, the victims' families were always allowed in first. But to answer your question, yes, they get priority, and then us low-level reporters, sometimes we would have to assign a pool reporter. And if we didn't get to be the pool reporter, we were not very happy. But anyhow, so... the secrecy is just beyond belief.
It feels intentional almost.
Yeah. So I don't know. Closing thoughts?
Yeah, I mean, closing thoughts. I wish we could have gotten to you guys with a happier, more informative topic. We got to you guys with secrets, more secrets. And what Andrew's crystal ball is telling us is that potentially some, arguments that are going to just get denied. So the case continues. We appreciate you guys getting to this point. If you watched up until this point, I always want to say, how grateful we are for you guys in the comments you leave down below. Let us know if you made it this far in the video. And I just appreciate you guys choosing to spend your time with us.
And also let us know if you think it's too. Some people have commented, you don't have a right to know. Some people put some comments down below and said, you have no need to know and everything should be kept private. Other people have agreed with me and the U.S. Supreme Court in the Nebraska Press Association case and saying, yes, we should know. This case is too tight. So let us know down in the comment section whether you think there's been too much privacy and whether they should open the doors. And on that thought, have a good one. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.